Welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries and relevant to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of 30 years experience. With me tonight I've got a partner in the law firm, specialised in workers' compensation, John Karantzis. Good evening, John.
Hi, Tony. Hi, viewers.
And also an associate in the law firm, running the Ringwood branch, Nadine Hanna. Good evening, Nadine.
Hi, Tony. Hi, viewers.
Tonight, viewers, we're going to be doing a WorkCover update, going through some very interesting and recent cases.
However, Tony, before we get to that, what's in the news?
Look, John, Nadine, there's been some very, very interesting stories. The first one I want to go to is this asbestos plant that was being run out of Ballarat Road by CSR.
Shocking.
And John, what's really astounding about this is that it was originally run by CSR and sold to James Hardy in 1977.
Yes.
But there didn't seem to be a clean-up when they closed the factory down. There, they've got a pokies venue, and apparently there's allegations of asbestos dust still being at the back of a premises on Crown land.
Oh yes, it's North Sunshine, a suburb in the western suburbs of Victoria. 16 people that we know of have died in this small radius. It's only a few blocks, isn't it, Tony?
It's astounding.
And it's an enclave whereby literally thousands of people could be affected, Tony.
And you know what's really outrageous about this, Nadine?
What's that, Tony?
A lot of people that have been affected were young kids that used to go and play there, and they used to bring the asbestos sheets and particles home, and they used to play with them, and they've since, a lot of them have passed away.
It seems like it's such an innocuous thing, but the effects have been so disastrous for the family members into the generations that have come in as it currently. So I suppose it's just a matter of real awareness that is happening now
all residents there should be aware of the effect and really seek medical attention, shouldn't they, Tony?
Well, there's a lot of people at the moment that've got plaques and they're being checked out on a regular basis.
Exactly.
You know, what I find astounding is back in the 70s, there wasn't much safety checks, was there?
Not at all.
These companies used to get away with anything.
Exactly.
What about Roberta Williams and her daughter, and also Carl Williams' dad, have apparently sued under the Wrongs Act to receive a payout for nervous shock? What do you think about that, Nadine?
It's a very interesting case by the seams of things, Tony. I mean, a lot of our viewers would remember how Carl Williams was killed whilst he was incarcerated, and it seemed to be a bit of a blind eye that was happening by the prison guards at the time of his death.
So, Tony, it's a claim in damages against the government
for nervous shock
and against the Department of Justice for failure to protect Carl Williams.
Yes, I mean, let's be realistic. The law's there to protect all of us. I mean, you know, unless we're going to be an anarchist state, which we're not.
No.
The reality is, he was a notorious underworld figure. He was in a cell. The warning signs were there. The Ombudsman found that there was a lot of...
there was a lack of security and a lack of procedures. So Roberta Williams is suing on the basis of a breach and in negligence, and as a result, she has suffered psychiatric injury.
Exactly. One of her claims, Nadine, is for dependency, which is... That is definitely rich, for the simple fact that if he was going to be in jail for 25 years...
Where is the dependency?
Exactly. They only get paid $25 a week. It's just enough to pay
So what about
cigarettes.
And the breach of agreement with the father?
That's a separate issue again.
So that's part of the claim, isn't it?
That is part of a claim.
So, and what's that all about, Tony?
Well, apparently there was an arrangement between Carl Williams and Victoria Police that by providing certain information, they would pay for tax bills, school fees of Dakota. There was also some suggestion that he was after a reward by providing information that would have led to a conviction for the Hodgson murders, but that's not going to happen now.
No.
But the thing that gets me, John and Nadine, is that if you're incarcerated and if you get compensation, it goes into a trust fund for 12 months to enable the community to sue you if they think they've got a claim against you.
Oh, okay.
Now, I guess in this situation, if they had a trust fund set up for 12 months again, notwithstanding the fact that you're not incarcerated, it might be a bad thing, because if anyone out in the community thinks they've been wronged by her or the father, they could go at that money.
Well, that's for the authorities to decide, Tony.
Yeah, it's something the Parliament can look at.
It's an interesting case.
Right,
but however, Dennis Napthine, the Liberal government leader of Victoria, did say they will vigorously defend the action, Tony.
But how are they going to do that? I mean, if the Ombudsman's found there's been major flaws in or breaches towards his safety,
I guess
you'd think that he's going to win on the issue of negligence.
We'll wait to see what the outcome is.
Yeah, we'll give you an update in due course. Nadine, tell us about this Melbourne Council getting sued by VWA because a company decided to go and play cricket and this guy's fallen over a bench.
It seems a little bit ludicrous, as Tony had said. It seemed like an authorised work activity, and they were out of the cricket ground at the time, and a gentleman seemed to have fallen over a park bench and sustained quite significant injuries. So here it is, it seems that the VWA has issued proceedings, or it seems to be more or less on the back burner at the time being, against the Melbourne City Council for those injuries that the worker had sustained.
So the great Australian pastime of social cricket on Australia Day, it's out the window, Tony.
Yeah, but John...
It's out.
But this
can't do it.
No, but this wasn't a proper oval. You had benches... A lot of obstacles in the way.
It was an oval in the city. It was a work function.
Well, he's fallen over a park bench.
Yeah. well, if you're taking a catch, that's going to occur.
That's what it becomes to the point where they were saying that they needed to have performed an adequate risk assessment to each of their to having the conducted, work function. But it just seems a little bit far-fetched.
These guys get a bit carried away. You know what it's like. You have a couple of drinks and all of a sudden you're taking speckies and everything.
Well, look, he did suffer an injury at the same time, the worker here. He did suffer a pretty nasty injury, but at the same time, we can't ban life, Tony, can we?
No. Look, I think predominantly the person responsible is the employer. It was an employment function.
It is.
Well, and I don't think the council's at risk. They shouldn't be, they won't be required to indemnify for the simple fact that I think, unless there are signs banning.
Yes, Tony, there was no signs. Okay. That's the problem.
Okay.
That is the basis of the claim.
All right.
If I was the worker's lawyer, I'd be suing the employer and the council.
Okay. Me too.
All right.
Me too.
For the councils out there, put up signs, you play at your own risk.
Exactly.
Okay? All right, let's get on. Firefighters. Voluntary firefighters have been harmed and are suing the CFA for failing to be proper warnings on the day of Black Saturday. What's that all about, John?
Tony, this particular case arises out of the events of Black Saturday. We all remember it in Victoria. That horrific day where over 100 people died.
Close to 200 people died, John.
Exactly. Yeah. In this case, one particular firefighter is suing again for the psychiatric injury sustained as a result of the negligence of the CFA in not warning the firefighters what was happening and the situation they were being placed in.
And it seemed that equally that the CFA had adequate warning and adequate knowledge at the time, didn't they, John, of the situation of the impending fire?
That's the allegation that they did, however, that was not expressed to the firefighters.
I mean, they were sent into what's been described as a death trap.
Yeah.
The fire's fast approaching and they weren't warned of that. Anyway.
Again, we'll find out what happens in due course, Tony.
Exactly. And he's suing for total incapacity for severe post-traumatic stress. Anyway, viewers, we've got to go to a sponsors break. Stay tuned after the break. We'll give you the WorkCover update. Viewers, welcome back to the show. As I said before the break, we're going to give you an update on WorkCover, which means we're going to go through a number of cases. Now, the first one is a matter of Green and Emergency Services Telecommunications Authority, which is a full court decision in the court in Victoria, 3 judges, and it deals with the Black Saturday fires. Now, Nadine, can you give us the facts of this case?
Absolutely, Tony. So this is an appeal case, and it's worthy to note at the first instance, a claim that has been brought on behalf of an injured worker where she was working throughout the period of her employment as a call centre operator and has sustained quite significant injuries to her arms, her forearms and her neck, and saying that it was due to the repetitive action and overuse of her, her extremities, and especially during the time of Black Saturday. And so this had ran for a 9-day jury trial and was unfortunately unsuccessful.
So Nadine, this action was brought throughout the course of employment, but in particular, the work that she was required to perform on the Black Saturday bushfires.
That's right. And she alleges that it was due to the high volume of calls that she was receiving on the day and that she was unable to take appropriate rest breaks, and they were considerably understaffed during that period, and there was a serious culmination of those injuries that came to head noticeably in that period of the Black Saturday tragedy.
John, what was she suing for? What did she want from the court?
Tony, physical and psychological injury arising out of the injury she sustained at work, and in particular on Black Saturday.
And what would that have entitled to her?
Pain and suffering damages.
Yes.
And past and future economic loss damages.
Okay. What's the maximum we can get under the WorkCover
Because
system?
as a result of her injury, she alleges that she can never work again. Now, for pain and suffering in Victoria, Tony, the maximum a worker can receive is about $560,000. It's not a lot, is it, Tony?
Well, it's pain and suffering. What about loss of income?
Loss of income, it's about $1.3 something million.
Okay. Well, Nadine, very rarely does anyone get 1.3 million because there's severe it's heavily discounted.
That's right.
Exactly.
That's
You've got the 6% discount, which is compounding, and you've also got the High Court saying you've got to discount it again.
For the vicissitudes of life.
Yes, yes.
And Tony, as we all know, those maximums are for the most severely injured, the
And you've got to be on
paraplegics.
very, very big incomes to get that, don't
Exactly.
you?
Tetraplegics, it's for those people.
What's the vicissitudes of life mean, Nadine?
Well, it's just to factor in the aspects of life that should be otherwise discounted. So I suppose if anyone would otherwise be unfortunately fallen sick due to any illness or tragedy or whatever.
walking outside and getting hit by a bus.
Exactly right,
Exactly.
but there's a discount that is applied to
The
that
vagaries of
factor.
life.
That's
Yep,
right.
Yep. John, this case had an interesting turn or twist to it.
Yes.
She failed
Yes.
in the first instance before a judge and a jury. Why?
A 9-day jury trial, Tony, which is very costly and expensive, as we all know. She failed. The jury came back and said no negligence. There was a no answer.
Why?
Tony, during the course of the trial, the lawyer for the defendant, as in the Victorian WorkCover Authority, alleged during cross-examination that the plaintiff, Mrs. Green, had concocted this story, had made up this story.
Okay. Nadine, on the issue John just raised, what they were alleging was recent invention. What they were saying was, this business about you getting injured on Black Saturday, you just made that up now.
That's right.
So you've just created this because it helps your case.
And not only that, in collusion with your lawyers.
Oh, that's bizarre, isn't it?
In preparation of the actual case.
That's
Now,
insane.
this allegation was made repeatedly in open court, Tony, in front of the judge and jury.
And it brainwashed the jury, Nadine.
That's right. Well,
Isn't that what happened?
that's what is alleged, and
Yeah.
unfortunately,
The jury
that led
heard
to the
all of
loss.
this. Now, after these allegations were put, which the plaintiff, Mrs. Green, strenuously denied, lawyers, the instructing lawyers for Mrs. Green, by email, advised the defendant, well, no, these are the initial file notes, and provided the initial file notes to the defendant, saying this is what she said when we first saw her. Black Saturday is my main problem.
Exactly.
And that was written.
And that was supported by 2 previous lawyers' file notes, wasn't
Well,
it?
that's
Exactly.
right. This was the third set of solicitors that she had right before the trial,
Yes.
and it seemed that it definitely wasn't a concocted story, and that though that panel or that solicitor for the Mrs. Green had also in his possession the other 2 file notes from the other solicitors.
Said that I was injured on Black Saturday.
That's exactly
Okay.
right.
But there's a problem, isn't there, Tony? What occurred was Mrs. Green actually did say that Black Saturday was my big problem when she first saw the lawyers. And secondly, the plaintiff lawyers herself did not raise the issue before the judge and jury. So the issue was sort of left to the judge and jury.
There's a problem with that, John and Nadine, because if you try and put in your notes about what was said to you as a lawyer on the first occasion, the real risk you run is that your whole file goes into evidence and you could be cross-examined on your whole file.
Well,
Isn't that a risk, John?
That would have been a stretch.
It's a big risk.
It's a risk, but I doubt that would have occurred.
Yeah,
It can occur,
there would have been a waiver of what we call legal professional privilege. I mean, I suppose if there's such a dependent claim on the notes, that if the notes were to be tendered, that there's an aspect of it that would be said, you know,
only that part would be waived.
That's
Exactly.
right.
But there might be comments in your file that are detrimental to a person's case, John.
Well, the problem was, and Tony, you're an experienced trial lawyer of 30 years. You would have made sure that this issue was again raised with the judge and jury.
What I would have done is sworn an affidavit saying, on the day I saw the plaintiff, this is what she told me, and I'd annexed that interview.
And you would have given evidence at the trial before the jury.
But I would have wanted to limit my evidence to the particular file notes.
Exactly.
And I wouldn't want to open up my file. So I'd say in the affidavit that I'm not, and I'd get the plaintiff to swear one too, Nadine, to say that I'm not waiving my legal professional privilege for the remainder of the file.
The problem is here, that didn't occur.
Well, that's exactly what the Court of Appeal had said. They were left a little bit flabbergasted that why the plaintiff's solicitors hadn't called the other two solicitors to give evidence and verify. They just kind of left the insinuation as it stands up in the air and not corrected.
They were worried about how the jury would receive it, but it sounds like the damage was already done.
Exactly right.
Exactly. So Mrs. Green has appealed this decision to the Court of Appeal.
Yes.
And the Court of Appeal has found in favour of Mrs. Green, hasn't they?
It was blatant what was going on, wasn't it, John?
The insinuation caused such severe prejudice to the workers' claim that, in effect, a retrial was ordered.
Okay.
That's right.
And that was the best result.
Well, I would think so. I mean, there was a real miscarriage of justice. I think that the initial instance, the way that the defendant solicitors or the defendant counsel had conducted themselves was a little bit left to be desired.
And the Court of Appeal has really made point of, if you make an allegation in open court, you have to have a proper basis to support that allegation.
Well, our duty as lawyers and as counsel is paramount to the court. We can't go around and fabricate these dates.
Which you can't stray from.
Right.
Exactly.
Viewers, we'll keep you posted on what happens with this case in due course. On that note, we've got to go to a sponsors break, so please stay tuned for the next couple of cases. Viewers, welcome back to the show. We've got to go through a couple of cases, so we've got to be a bit quicker than last time, guys. Now, Nadine, there's a case of L versus Sydney's American Imports Proprietary Limited, deregistered. This is a very sad case, but a bizarre case at the same time. Give us the facts as succinctly as you can.
So this is a case that has been brought on behalf of a widow as her unfortunate late husband was killed due to tragic circumstances. It seems that he was an automotive or authorised car dealer, received a phone call on a particular date in 2005 to inspect a prestigious car, and he says to his wife, "Honey, I'm not going to be gone for too long," and off he goes, and unfortunately was killed and thrown off the gap in New South Wales. Now, the interesting part about this case is that he was found that he was continuing to be working, and he knew that the assailants at the time who had murdered him as well.
Okay. John, so we got this fellow who runs a dealership of sorts.
It's a very peculiar case, Tony.
Now, he gets a call, just like any good businessman, goes there to try and do a deal. But what happened then? They tried to kidnap him. They wanted money.
Yes, he's an authorised dealer for prestigious cars.
Okay.
So part of his job, Tony, was to go and see these cars at all sorts of hours.
Yep.
And it was a normal part of his duty that, in the early evening, he'd go and check cars. And in this particular night, he receives a phone call from an associate who is unknowing to him, setting him up to be kidnapped.
It was a reasonably unsavoury sort of character, this bloke, wasn't he?
Exactly, and eventually murdered.
Okay.
Now, the deceased's wife, as Nadine rightly pointed out, has made a claim for dependency benefits under the New South Wales WorkCover scheme.
Okay, so the issue here, Nadine, was he still working when he was murdered? That's the issue before the court.
That's right.
Okay.
Yes.
What did the court find?
Well, the court had found that his acts were not inconsistent with his employment. That is, that they found that it was a continuation of he was working, even though that he was in front of these two particular assailants at the time, and therefore was awarding the benefits to the wife at the time.
Now,
Well, John, what it means effectively is that this wasn't a 9-to-5 job. The fact that he went there whatever hour is irrelevant because he was a dealer and the work came when it came, correct?
Exactly. Look, the court did state that this is a very broad interpretation of in the course of work.
What I found astounding, Nadine, is that during this, there was evidence, because everyone got convicted in the end, that they said, give us some money or we'll throw you off. He refused to pay the money over, so they just threw him off the gap. Yeah, that's extraordinary.
Yeah, that is. It really, and it's almost a little bit sad that this situation had occurred. I think that the fact that there was a connection between the employment's a very broad one, as John had indicated.
It's broad, and also there were allegations, because as we know, an informant had basically spilled the beans on what happened. Now, the deceased himself, it was alleged, was part of this criminal endeavour, as in he'd received stolen cars, stolen monies, drugs, all these allegations were made.
They were known to each other.
Exactly.
And in fact, there was some suggestion, Nadine, that he owed money or there was some deal that went bad with the guy that was trying to extort him.
But nonetheless, the court found, putting aside all those criminal issues, it's still, the deceased was killed in the course of his work, and therefore the wife deserves to receive dependency payments.
In Victoria, John, if this was a Victorian case and it was found for the widow, what would she have got in Victoria as a dependency claim?
Oh, over $500,000, Tony.
And that's a no-fault component?
That's a no-fault component.
Then, if you could prove fault, Nadine, which I'm not sure if you can in this case,
I think this is
you could go well over and above that, can't you?
Yeah, for damages, yes.
So
it's a very big claim, and also ongoing dependency benefits for any children involved.
Exactly, and that can go up until the age of 25 or when they finish school.
Yeah, so it's quite significant.
All right, tell us the facts of the next case, John. Very interesting case against Beta.
Oh,
Beta's got a bit of it's a reasonably infamous...
Tony, well, you and I have sued Beta Poultry quite countless times, haven't we, Tony?
I think so.
For employees injured in the course of work. It's a company that works their workers very hard, and well, the results in regards to these cases prove it, don't they?
Beta is a poultry farm. Yes. Probably one of the biggest chicken farms.
Exactly. It's a processing farm, and in this case, the contractor Gary Bennett, he was a truck driver. His job was to deliver poultry, the chickens, to various outlets. Now, the employer, as in Beta Poultry here, would basically fill the back of his truck up, and he would go around then delivering all these chickens. The problem was the way it was stacked in his truck. They were stuck together. And in one incident, juice is dripping, and it was really hard for him to get the pellets out of the back of his truck. During the course of one of these instances, he's done his back, Tony.
Well, he's done a cross fracture of his lower back.
Exactly.
Nadine, this comes back to what you said before. The company failed to do a risk assessment of the way they stacked these pallets. What's a risk assessment, mate?
Well, it's an assessment done to be able to analyse the risk that it could be potentially imposed in the particular act of to the worker unloading or loading vehicles, or
well,
in
it's
any
basically
instance.
the employer turning their mind to the duties and tasks the worker got to do.
That's right.
To see if there's any risks, unnecessary risks associated with those tasks, because the duty is only a reasonable duty of care, isn't it, Chuck?
Always.
It's not an absolute
No,
duty.
no. Reasonable.
Yep.
And in this case, Tony, the worker has sued for the injuries. He's alleged that a breach in negligence and claim for pain and suffering and economic loss and gratuitous care because it's New South Wales, Tony.
Okay.
And the result was the court has awarded him over $670,000 in damages, Tony.
Of which future loss of income was $315,600.
And it's worthy to note as well, this particular plaintiff was 62 years old, so it's quite an astronomical
Do you know what's
figure.
extraordinary about this case, Nadine? There was so many other instances of injuries occurring at this particular place.
Oh, yes.
I mean, were they...
It's countless.
Were they put into evidence as well?
Yes,
John?
Tony.
Oh,
Yes.
they were?
Yeah.
You're allowed to put those in? I guess it all comes out,
Well,
doesn't it?
I suppose that the overall system as to the type of employer could be relevant.
So if this was before a jury, it'd be overwhelming, but it wasn't a jury, was it?
No, Tony.
In New South Wales, there's no juries, viewers. The jury's only in Victoria. Anyway, on that note, is there anything else you'd like to add, John?
Oh, Tony, apart from these type of cases, viewers, anyone injured in the course of work has an entitlement to sue for damages, sue for lost wages, medical expenses and lump sum claims.
Nadine, thanks for coming on board. John,
Thanks for having me.
It's always a pleasure to have you
Thank
on
you,
board.
Tony. Thank you, viewers.
Viewers, thanks for watching. Go to our website, go to Facebook, Twitter, and all the other beautiful social media things. And viewers, stay tuned for future episodes and always remember to stay safe.